Good evening. Thank you so much for joining us. We are here at Fox 26, the vodcast room, and we've been closely monitoring the trial with Gerald Goines and his murder trial. We do know that closing arguments just wrapped up. They started today, so we do want to make sure that you are able to see everything that both sides had to say. Here we go.
May I proceed, Judge? It is offensive that 6 years later, 6 years after the fact, we are still trying to justify
May I proceed, Judge?
Yes, sir.
Justice? I think most of us think that we're just. And I think most people want to be just. Most of us. But I also believe that that concept of justice is certainly shaped by our own life experiences, our own individual perspectives. And for that reason, I believe that justice can be defined in a lot of different ways. But I also believe that justice has some foundational bedrock principles that will always be true. Justice is most necessary in the wake of injustice. And the deaths of Regina Nicholas and Dennis Tuttle are a grave injustice. I also believe that it's an irrefutable fact that justice depends on the principle that every man and every woman is created equal. In other words, no one is above the law. And most certainly, no man and no woman are below the law. I don't know if you have ever seen a picture or a painting of Lady Justice. She's the statue that personifies justice. And in one hand, she holds a scale, and it balances justice. But if you pay close attention, Lady Justice is blindfolded. And that stands for the principle that just because you have a badge doesn't mean that you're above the law. Just because you struggle with depression or mental illness doesn't mean you're below the law. Being entrusted to protect our community as a police officer does not give you license to violate someone and their rights simply because you think they use or they deal drugs. The Fourth Amendment to the United States Constitution, the right that we all have to privacy in our homes, applies equally to every man and woman. Throughout this trial, it's almost felt like we've been playing tug-of-war with that blindfold on Lady Justice. Because it seems as though Mr. Goines truly believes if he can devalue Mr. Tuttle and paint Miss Nicholas in a different light, in a negative light.
Objection, Your Honor. Striking at the defendant over the counsel. Shoulder of counsel asked that the jury be instructed to disregard. Please disregard that last statement from the jury.
Just because these complainants in this case have been painted in a certain light does not speak to their right to privacy in their homes. The defense in this case has called 3 witnesses. Every one of those witnesses came here to testify about what happened after this murder took place, to comment on the character of the complainants.
Objection, Your Honor. Misstatement of the evidence.
To comment on the character of the complainants in this case that had absolutely nothing to do with the indictment you're asked to decide. I've tried a few cases in this courthouse, and I've come to believe that every single verdict in this courthouse is a product of 3 variables. You have the law, you have the evidence, and you have the jury who applies the law to the evidence. When the law is clear, and the evidence is clear, The only thing left to manipulate is you. Do not be manipulated in this case. There is a long line of people who have already been manipulated by Mr. Goines in this case. Let's go back to January 28th of 2019. And you look at the search warrant that's on the screen there. Gerald Goines lied to the face of Judge Markham. He defrauded Judge Markham when he went in there to get this no-knock search warrant. And based on those lies, Judge Markham says, I further find that the affiant has established sufficient reason to believe that to knock and announce their purpose by the officers executing this warrant would be futile, dangerous, and otherwise inhibit an effective investigation. Signed, Gordon Markham, presiding judge, Houston Municipal Court 13. Judge Markham was absolutely manipulated and defrauded. What about Lieutenant Todd, a seasoned narcotics lieutenant who went to the hospital to speak to Gerald Goines to try to further help him to identify who was the confidential informant in this case? Let's get this taken care of. And what does he say? He gives her the name Reese. I apologize, my clicker's not working well, guys. He gives her the name Reese, and he knows that this is not a CI that he used. He already knows. He's never used a CI. But this level of manipulation goes up a notch because he also writes, but she's gonna be scared, right? She's gonna be scared because he knows when Lieutenant Todd calls her, she's gonna be oblivious to Harding Street. And so he's manipulating already by saying she might not acknowledge that she's the CI. She's gonna be scared. When his friend and co-officer, Stephen Bryant, called Gerald Goines and asked Gerald Goines, do you need a favor? Do you need me to tag the drugs out of your car? What did Gerald Goines do? He manipulated his officer, his friend, Stephen Bryant, and said, go to the center console of my car. There's some heroin there. You can tag that as if it's from Harding Street. To me, this is the peak of injustice in this case. Around the same time that the Tuttles and the Nicholases are getting calls from the police to say, hey, I'm so sorry, but your family members have been killed. Gerald Goines is planting heroin on them. That's what this case is about. Over the last 2 weeks, we've been discussing the worst case scenario in that house. But I implore you to think about the best case scenario. Think about that. Think about the best case scenario in that house. If this false warrant played out differently, the best case scenario was that Dennis Tuttle and Regina Nicholas are wrongfully convicted of possessing drugs. And that warrant, no one ever knows that it's false. Instead, we have Mr. Goines, who's going to pad his pockets from working overtime, and instead of and while he's at that restaurant, when he's supposed to be investigating this case, he's actually profiting off of wrongfully convicting those two individuals. That's the best case scenario for Gerald Goines in this case. There isn't a single scenario in that home where justice prevails on January 28th of 2019. After unknowingly planting these drugs, Stephen Bryant came to the hospital. And he asked Gerald Goines, man, let's get this taken care of. Who's the CI? This is Gerald Goines' friend. Let's get this taken care of. Who's the confidential informant? And he gives him a name, lies to Stephen Bryant. Stephen Bryant vets that name, realizes he's been lied to by Gerald Goines, and he comes back. He said, Gerald Goines, look at your phone and point here. Who is the CI? And I know all of you know what Gerald Goines did. He points back at Stephen Bryant to manipulate him and say, you find the CI. When he was so clearly caught in this lie, did he ever come clean? No. He doubles down on his manipulation, and he asks Sergeant Bass to come take a statement from him. You remember that? It was in February. And he says to Sergeant Bass, via writing, of course, says to Sergeant Bass that he was the confidential informant in this case. It's all good. I did a full investigation. I went to that house. I know these people are drug dealers, continuing to stain their reputation. I went there on 1/27 in the evening, but that's clearly not true. See, Mr. Goines didn't know that we could disprove this manipulation, this lie with his phone records. And then Sergeant Bass continues to ask him, well, what did you buy? Remember, Gerald Goines says in that TAC plan, he's never been inside that house. He admits that. But to Sergeant Bass, he says, I bought 2 baggies of heroin. Again, continuing to try to plant heroin on people that he has just murdered. He says, I believe I tagged it. He knows that's a lie. And those are the drugs right there. He says, did I not tag the evidence? Oh, I'm sorry, I didn't tag the evidence. And then when Bass shows him those drugs, he says, well then yes, that would have been the drugs that I bought from that residence. Not only continuing to double down on the manipulation, but double down on the planting of heroin on dead individuals. And speaking of Sergeant Bass, I think it's absurd to suggest that Emma Rodriguez is the lead homicide detective in this case. That's just not the facts. This investigation was split into 2 investigations. You had the investigation of the shooting side of things, which was Lujan and his team, and you had the warrant investigation, which was Sergeant Bass and his team. Sergeant Bass was the sergeant, the leader, the supervisor of that squad that Emma Rodriguez was on. And you don't have to believe me that she's not the lead homicide detective. Just use your common sense. If she was the lead homicide detective, why wasn't she the one that was interviewing Gerald Goines? If she was the lead homicide detective, why did Sergeant Bass write every search warrant in this case? If she was the lead homicide detective, why is Sergeant Bass the one who's interviewing confidential informants? If she's the lead homicide detective in this case, why is Sergeant Bass searching Mr. Goines' vehicle and Mr. Bryant's vehicle? See, that whole thing that she's the lead detective is just to play you, to make you grasp your pearls and think, oh, the state didn't call the lead homicide detective. Don't be manipulated. Throughout this case, Gerald Goines has manipulated a judge, a sergeant, a lieutenant, a friend. You think you're off limits? I can remember clearly the first thing the defense stood up and said during their opening statement, and I bet you can too. It was somewhat shocking. They said, Gerald Goines lied in that search warrant. Remember that?
Objection, misstatement of the evidence.
He certainly stipulated that he didn't use a confidential informant throughout this trial. But I also remember the next sentence was back to that same playbook. The next sentence was, but the cause of this death was Regina Nicholas and Dennis Tuttle. See, it wasn't enough for Mr. Goines to murder those 2 individuals. He has to murder their reputation too. Because he knows that if you focus...
Objection, Your Honor. That's a comment on failure to testify to talk about what he knows. He asked the jury be instructed to disregard. As required by law, we request a mistrial.
May I proceed, Judge? Yes, sir. Mr. Goines understands if you focus on the indictment and the law in this case, his charade's over. It is. I want to look at the language in the indictment in this case. And this is straight from the indictment. And I know it's a lot. And you probably remember, I know it was eons ago, but we sat and we talked about this indictment in jury selection. And we actually broke it down into 3 boxes. I know you remember these colors. I know you remember these boxes. So that first box is that tampering, that underlying felony. And I don't think there's any doubt in this case that Mr. Goines is guilty of that. You could check that first box off. But let's read it. It says, tampering with a governmental record by making, presenting, and using a governmental record with knowledge of its falsity. Now, Mr. Goines certainly made that search warrant affidavit. He certainly presented it to Judge Markham. He certainly used it when he went to Harding Street, and he knew it was false. Both a search warrant and a search warrant affidavit are governmental records. Do not get hung up back there thinking about that. Let's look at the next way that you could, this next box. It says, tampering with a governmental record by possessing a governmental record with intent that it be used unlawfully. That most certainly took place as he possessed it on his way to see Judge Markham, after he left Judge Markham, and when he went to Harding Street. And he certainly knew that he was going to use that unlawfully to put together an attack plan and to send armed peace officers out there. There is no doubt that you can check that first box off, period. The second box there, an act clearly dangerous to human life. And we talked about this, and in fact, I think every single person that took that stand, maybe minus one or two, but almost everybody on that stand told you, a no-knock search warrant is dangerous. And the only way to make it safer is to gather intelligence, gather information. But if you don't believe me, let's look at some of the evidence. Sorry, I should have pointed this out, and I apologize. Back to that first box. You are not required to agree unanimously about which one of those two ways he's tampered. It could be 9-3, 6-6. As long as the 12 of you do agree that he tampered, you're done with that box, okay?
Objection, Your Honor, that's a misstatement of the law as it relates to several of the instructions in the jury charge.
Sustained. Ladies and gentlemen, the law in this case is coming from this jury charge, okay?
That's correct, and I'll restate it if I stated it wrong. You do not have to unanimously agree. If you go back to that slide, this is actually taken straight from the instructions. In order to find the defendant guilty of the offense of felony murder, you are not required to agree unanimously on if the defendant, Gerald Goines, and then it lists those ways that you can tamper, okay?
Again, that's an incomplete description of the law, so it's a misstatement of the law. We would ask that the jurors be instructed to disregard and refer to the court's instructions.
Thank you, Judge. This is the language in that search warrant. We'll go back to it for a second. He says there's a white male who he doesn't even know because he's done no research, who's 5'11" and 55 years old, wrong, wrong, who's 180 pounds, wrong by quite a bit because you've never seen Dennis Tuttle. He says that there's a belief that they have possession of heroin. Nope. Affiant has good reason to believe, does believe, and hereby charges and accuses that on January 27th of 2019, they were in possession of heroin. No, that'd be Gerald Goines that was in possession that day. On 1/27/2019, your affiant contacted the below confidential informant regarding the above location mentioned above. Your affiant met with the confidential informant to further the narcotics investigation. Lie. The quantity of brown powder substance purchased at the above residence, located at 7815 Harding Street, on 1/27/19, was recognized by sight and texture as heroin by your affiant, which is Gerald Goines, and Officer Stephen Bryant. I could have had 7 more slides with the lies in that search warrant affidavit. It is riddled with manipulation and lie. Now, back to that second box of whether or not this is an act clearly dangerous to human life. If we look at this particular slide, you can see that the cause of that warrant, the natural flow from that warrant, was that these armed peace officers showed up to 7815 Harding Street. You had multiple people testify, but for that warrant, no one in this picture is on the street that day. And to look at this picture, you can tell how clearly dangerous this operation is. They're all armed, they're all in tactical gear, most of them have multiple firearms and extra magazines that have extra bullets. If you look at the next picture here, this to me is the depiction of just how violent this activity actually was. Because this is the diagram that notes the shots that hit the outside of that house. Right? These are officers, mostly Gallegos, who admit, I shot some through the doorway, but I also, he admits, shot blindly through the side of that house with an AR-15. And because Gerald Goines had never done 1 second of homework on this place, no one out there knows, are there kids in that house? What's going on in that house? And instead, they unlawfully just blast shots through the siding of this house, not knowing who's on the other side. There's absolutely no way to categorize that as lawful force. If we look at the next slide, this documents only the bullets from the inside of the home and where they struck. Clearly a dangerous situation. And these clearly don't take into account the shots fired from Mr. Tuttle, because those are alleged to have hit officers. So everything you see on this screen are shots fired by police that are illegally inside of this home because of Gerald Goines. But for Gerald Goines, this slide is blank, period. And then if you have any doubt that this is clearly dangerous to human life, this picture encapsulates the tragedy of the inside of that house with a dead dog, a dead wife, and a dead husband. Box 2, you can check that off. There's no doubt about it. So let's talk about box 3, which is, did he cause the death of these two individuals? And I want to show you the definition of causation. Again, this is directly from the instructions that you just got. There's nothing more to it, and there's nothing less than this. It says, a person is criminally responsible if the result would not have occurred but for his conduct. Another way to ask that question, if you take Gerald Goines out of Harding Street, what takes place there that day? That's what that first sentence stands for. But for causation. And it says, operating either alone or concurrently with another cause. The principle here is the actor that's on trial does not have to be the only cause. That's what that's telling you. They could be operating alone or with another cause. So if you go back and you think, man, I think these officers share some blame, or that 911 caller shares some blame, you're well within your rights to think that. That doesn't absolve Gerald Goines of liability here. This is but for causation. It does not have to be the only cause. And I remember we talked about that in jury selection with a lot of you. Now the second part of this says, unless the concurrent cause was clearly sufficient to produce the result, and the conduct of the defendant clearly insufficient. So to break that down, if you remember, I've already alluded to it, but when the defense stood up and said, the cause of the death in this case is Regina Nicholas and Dennis Tuttle. That's what they told you. So they're saying that that is a concurrent cause that would have happened if Gerald Goines had never been there.
Objection, that's a misstatement of the law
So ruled.
and a misstatement of the evidence.
That's sustained.
And ask that the jury be instructed to disregard
Please disregard that as comment.
as the law requires for a mistrial.
Be denied. Please continue.
They're arguing that the concurrent cause in this case is that they caused their own deaths. And that their actions, just their actions, would be clearly sufficient to take their own lives. And we know that's not the case, because the police that were in there, directed by Gerald Goines, took their lives. Another way to say this is for 59 years, Regina Nicholas and Dennis Tuttle had an opportunity to take their own lives. Mr. Tuttle, as you saw in his medical records, he lived with constant mental and physical anguish. And yet he always maintained throughout all of that, I'm not suicidal, I'm not homicidal, and I'm not a dangerous person. If you take Gerald Goines out of the equation, do you think that Regina Nicholas and Dennis Tuttle caused their own deaths? It's that simple, and you know the answer to that question. There's one person in this world who has the blood of Regina Nicholas and Dennis Tuttle on their hands. It's the same hand he raised in front of Judge Markham when he smiled and lied. And now he's using that same hand to point at the victims in this case and say it's your fault.
Objection, Your Honor. Comment on the defendant's right not to testify.
So ruled. Please continue.
Everything that happened in that house, everything, flowed directly from that warrant. It is a direct consequence flowing from that warrant. But for Gerald Goines, those two individuals are not dead. Period. Now, this may be the most important thing I say about the law in this case. We're here to decide a felony murder case. We talked about this in voir dire. That's different and distinct from a murder case. Felony murder does not contemplate, did Gerald Goines intend to cause the death? It does not contemplate that. It does not contemplate self-defense. It does not contemplate that. You are only asked under the law of felony murder to evaluate the indictment and to ask yourself and make the single determination, did Gerald Goines commit a felony, of course, that led to an act clearly dangerous to human life? Absolutely. And but for that, Regina Nicholas and Dennis Tuttle would still be alive. Most obviously, yes. The answer to all three of those boxes is yes. Now, I do want to show you a part in here that describes when an officer can use deadly force. And again, this is taken directly from the law, from your charge. It says a peace officer is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary. Now remember, the shots that happened in that house happened long before those officers ever saw a gun. Those shots in that house happened before they were shot at. So you're still evaluating, was the force they used immediately necessary? That's step one. Again, this is talking about the people who shot, okay? The actor reasonably believes that the arrest or the search is lawful, or if the arrest or search is made under a warrant, he reasonably believes the warrant is valid. Well, we know this cannot apply to Gerald Goines then, right? He does not believe this is a valid warrant. He knows he lied. And before using force, the actor manifests his purpose to arrest or search and identifies himself as a peace officer. Of all of the evidence in this case, there's only one person that says they said police, and that's Medina, the only person. He also happens to be the same person who said he was giving commands to Miss Nicholas, and you never hear any of those things on the body-worn camera. But before you get too caught up thinking, did they or did they not announce, this law doesn't apply to Gerald Goines. He knew that warrant was invalid, okay? Now let's look at deadly force. This is the next step, not just force, but deadly force. It says a peace officer reasonably believes the deadly force is immediately necessary to make an arrest. You've heard from different people here. They could have made this arrest in various different ways. They could have waited until they came out of their house, did a traffic stop. They could have knocked on that door, said, hey, we're the police, can we talk to you? Deadly force in this case was never, ever immediately necessary for an arrest, ever. And then it says, and this is very important because these all have to be satisfied. It says, and the actor reasonably believes the conduct for which the arrest is authorized included the use or attempted use of deadly force. In other words, if they're going to make an arrest for drugs, this law doesn't qualify. Because it's saying the actor believes the conduct for which the arrest, in this case, possession of heroin, included the use or attempted use of deadly force.
Objection, that's a misstatement of the law, of how the law is applied.
Ladies and gentlemen, the law in this case comes from this charge. Whatever either side says, their opinion about the law. Please continue. You've got 5 more minutes for 30.
Thank you, Judge. Remember when I asked Sergeant Wolf if there was a different legal analysis for the officers that were shooting as compared to the mastermind, the case agent? And he said twice, yes, there's a different legal analysis. Remember when I asked Sergeant Guerra, said, is there a different legal analysis between the officers who were shooting and the person who wrote the warrant? Yes, there's a different legal analysis. And when I talked to Sergeant Guerra, I gave him that hypothetical. I said, Sergeant Guerra, if you and I went to go burglarize someone's home, and I was the mastermind that planned it, and I recruited you, and you brought your gun, and we kicked in that homeowner's door, and they shot, and they killed Sergeant Guerra, that homeowner is wholly justified in their actions. They can shoot all day long. Nothing wrong with that. But me, the mastermind of that, I am guilty under the law of felony murder because I created that dangerous situation. That's what this law is all about. It's not about is justified force used. We know it isn't, but that's not the question. Don't get bogged down in the weeds. This entire question you have to answer is summarized in the indictment, and it's as simple as but for Gerald Goines, these people would be alive, period. The truth about this case is that Dennis Tuttle and Regina Nicholas, they could have been the largest drug kingpins in the United States. And Dennis Tuttle could have been waiting behind that front door for the police to come in. And when the police kicked that door in, using Gerald Goines' warrant, and Dennis Tuttle kills the police, it's Gerald Goines who's guilty of felony murder.
Objection, misstatement of the law. And we would also argue that it is an inappropriate argument for the application of the law in this circumstance.
That is the stand.
Ask that the jury be instructed to disregard.
Disregard that last comment.
Ask for mistrial.
That we deny.
You're evaluating the environment and the situation that was created by Gerald Goines. You're not evaluating individual actions within that house.
Objection, Your Honor. Again, misstatement of the law and application of the law.
That's all.
Under the applicable law in this case, Gerald Goines is absolutely responsible for every bullet that's fired by officers and by Dennis Tuttle, period. The felony murder in this case, the only question goes back to that indictment and those 3 boxes, period. Now, I do want you to at least consider the special issue that Judge asked you about in that jury charge. It was about a deadly weapon. And it said whether or not Mr. Goines used or exhibited a deadly weapon. I'm not here to tell you he fired a gun, but I am here to tell you that he took his AR-15 there and he took 2 other guns and he exhibited a deadly weapon throughout this entire search warrant execution. That would be the answer on that special issue question. Now, I do want to talk to you about some of the other slides here. The jury charge contemplates some other offenses, namely the tampering with the government record. And it says, I'm going to read straight from the charge, if you do not find from the evidence beyond a reasonable doubt that the defendant is guilty of felony murder, or if you have a reasonable doubt thereof, you will next consider whether the defendant is guilty of one of the others. So this is directing you that you begin your deliberations at felony murder and you don't move on to the other offenses until you decide on felony murder. And of course, it's our belief that Gerald Goines is guilty of felony murder. It's very obvious. And so here, you do not have the burden of having to worry about those other offenses because you don't move on to those until once you've considered felony murder.
30 minutes.
Thank you, Judge. Now, the fact that there are other potential options here, that's not a comment from the judge that some of these are the right answers. That's a very normal practice when you have a charge that also subsumes other charges within it, okay? So this is what your verdict page looks like. Now, there's a couple of different verdict pages because you have 8 options. That second option there that I have highlighted is obviously what the state is asking for. That Gerald Goines be found guilty of felony murder in this case. Every offense below that is a different offense that's subsumed within that felony murder indictment that you could evaluate on its own merits. But once you sign guilty of felony murder, you don't sign any other part of this verdict sheet. Okay? Now, I've been asked about this case, if you don't mind clicking a little more. I've been asked about this case, and I've thought about this case for a long time, and thought about the best way to describe this case. And once you get past tragedy, and you get past disgust, I think you land on irony. I think it's incredibly ironic that the only person who ever possessed heroin during this case was Gerald Goines. Had it in his car for a week and then planted it on Harding Street. I think it's incredibly ironic that Mr. Goines couldn't be bothered to investigate the individuals in that home or what was taking place in that home before getting a warrant. But now because he thinks it'll help him, he wants to talk about what happened in that home and the texts that were sent from that home and the drugs that were found in that home. The time to investigate those 2 individuals was before they were murdered, not now. I also think it's highly ironic that the bullet that he is responsible for, the bullet that silenced him, kept him from communicating with his confidential informant and calling them and saying, hey, I need you to say you did an investigation at Harding Street.
Objection, Your Honor. There is no such testimony in the record or evidence of any kind.
Is our-
The statement of the evidence.
I'm saying that it's ironic that he wasn't able to do that. And it's due to his own actions. And if you're thinking, well, he could have just texted them. Yeah, that's true. But he couldn't ensure that the CI would have deleted their texts. So instead, because of his own actions and the silence that was created by the bullet he's responsible for, he had to write the trail of his lies. I also think it's highly ironic that this whole trial started, this whole incident started with Gerald Goines abandoning his oath in front of Judge Markham. And as we sit here today, now Mr. Goines is asking you to abandon yours, asking you not to follow the law in this case.
Objection, Your Honor. That is an improper argument,
Stand on that.
and ask that the jury be instructed to disregard.
Please disregard that last statement.
Ask for mistrial.
We deny it.
May I proceed, Judge?
Yes, sir.
Perhaps the richest irony of all in this entire case is that we spent days and weeks in jury selection making sure that each of you could afford Gerald Goines the presumption of innocence and the right to a fair trial. And I'm very happy to say that we have. But as I sat there in jury selection, I couldn't help but think, had Mr. Goines afforded that same courtesy to Ms. Nicholas and Mr. Tuttle, we wouldn't be here. See, the time for their trial has come and gone. This is the trial for Gerald Goines. Now, the 15 of you, you're no accident. You're not a coincidence. Every one of you is specifically here for a purpose. It's undeniable that your verdict will have an incredible impact on Gerald Goines. It's undeniable that your verdict will have an incredible impact on the Tuttles and the Nicholases. But it's also just a fact that your verdict will have an impact on this community. You're about to speak for your neighbors, your friends, your family, and millions of people you've never met. And I don't say that.
Objection to the improper plea for law enforcement.
Please continue.
I don't say that to overwhelm you. I say that because you are the perfect group to answer the ultimate question. Since the Fourth Amendment was written in the Constitution, and our right to privacy in our homes was put to ink, there's a special peace and a special comfort that a citizen enjoys behind his closed front door. Gerald Goines has put that peace and comfort on trial. Our community cares so deeply about this case, not because they know Reggie Nicholas or Dennis Tuttle, but because they want to know the answer to this question.
Objection, Your Honor. That is improper argument.
That's sustained.
And ask that the jury be instructed to disregard.
Please disregard that last statement.
Ask for mistrial.
We deny it.
Let me ask this question. When an officer lies and he forces a group of armed peace officers into a home, and those officers knock down the front door, and they shoot first and kill the family dog, and then they shoot and kill an unarmed wife, and then they shoot multiple times into the back of the husband, one through the back of his head and out of his mouth, who's responsible? Is it us, the homeowner? Or is it the liar that set this all up?
Sorry for the podium, but my eyeballs can't see as far as his. May it please this honorable court, members of the jury, good morning. Nice speech. I want to talk, and this is going to be a little laborious because I want to take you back, not through the hyperbole, not through the catchphrases to tug at your heart. I want to tug at the facts. And this part of the proceeding is known as final argument. I assure you, I have no argument with you. I have argument with them. But I'll do it professionally. And what I'm going to take you through is the evidence. Because what the evidence shows, this case is overcharged. It should never have been charged as a felony murder. It got amped up to felony murder, our perspective, because of the politics of their office, because of the media outcry with 2 citizens being killed in their home and 4 officers being seriously injured. It cried out for some kind of demonstration at the courthouse. And the problem is, and of course you guys are all on the jury because you didn't listen to all that crap, is that most of it was based on misleading information. This business about the officer just burst in there and mowed people down, that's the narrative in the media, but now you get to see the facts, and that's not what the case is about at all. That's not what the evidence showed at all. Now you're going to be angry, and Nicole told you this during opening statement, with Gerald for the false statements in the affidavit. I get it. I get it. As an officer of the court, I don't like it at all. But the question is, what is Gerald guilty of? We discussed this ad nauseum in 11 days of jury selection with you folks. We took you through it. We talked about overcharging. We talked about the concept of felony murder. And guess what? We end where we began, because where we began is this concept of causation. The dominoes, you all had to suffer through all that. A, B, C causing D. Well, now we're here. Except now you have context, and now you have the law. And I'll submit, because of cross-examination, now you have the facts. And I ask you while I go through this, bear in mind, what did you hear on direct examination? And if we had a myocardial infarction and you didn't get to hear our side, what impression would you have been left with if you'd based your verdict only on what they brought out on direct examination? Ask yourself that. Did you learn anything new? Did you learn anything different? When all of a sudden Gerald Goines' constitutional right to confrontation and cross-examination came into play, what did you learn then? What information did they hide from you that we were able to bring to light of day when we had a chance to ask questions? The evidence shows that the complainants in this case would not have died, would not have been hurt, had they complied with the officer's directives. It's as easy as that. Remember Vordaer? If a search warrant is bad, what is your remedy as a citizen? You get to go to court. You get to sue the hell out of them.
Judge, that's not an evidence. That law is not an evidence either.
That's exactly what the law is. That's your remedy. We discussed it with every one of you in Vordaer. That's your remedy. Heroin, falsely planted, what's your remedy? Or search warrant based on inadequate probable cause, what's your remedy? You file a motion to suppress and the evidence is suppressed. Now that doesn't make what Gerald did is right, but the point is, as sorry as you may feel for any citizen when police officers come into the home and they shouldn't be there, when that happens, that's wrong, and they should be held accountable. But the homeowners do not have a right to assault the police officers. We discussed that at great lengths, and it's in the jury charge, and I'll go over that with you in a moment. But you know, I listened, and I'll tell you this, I submit that any death is tragic. Any and every death is tragic. I fought all my career in this courtroom fighting death penalty prosecutions. Any death is tragic. But there was not a grave injustice in this case. And I listened, but one thing I never heard, Mr. Keaton, Mr. Force, my friend Keaton, is a formidable advocate. Wait till he's my age. He's a heck of a job. Listen to him. He's bright. He's good. But I listened. I never heard anything about the facts of this case. You know what they don't want you to do? What did Ranger Wolf tell you? 80 seconds. That's all it took, 80 seconds in that house. They don't want to talk about the 80 seconds. Did you hear him say anything about Dennis Tuttle firing the first shot at a human being? Did you hear him say anything about Dennis Tuttle deliberately, all too accurately, firing his weapon into the head of 2 officers, into the neck of 1 officer? Do you think that was he just got lucky? We didn't hear anything about that. They don't want you to consider that. Because of a false statement in a warrant, because the officers shouldn't be there, it's okay to try to mow down the cops. That's not the law here, but they don't want you to consider it. And think about the facts, and I'm going to take you through it in a few moments. But just as an introduction, what do we know? We know that when the officers entered the premises, and I'm going to spend some time on the announcement of who they were and why they were there. But when they entered the premises, it was Regina Nicholas yelling, "Motherfuckers, motherfuckers." And then the next thing we hear is dog, and then Officer Medina and Officer Loving fire upon the dog, and the evidence is the dog was aggressive. They knew that before they went in there, and in fact, when they went in there, the dog was aggressive. They followed policy and they neutralized the dog. And then what's the next shot? The next shot is Dennis Tuttle shooting Officer Medina, causing him to go backwards, landing into the south side of the couch. Went over it a number of times. And then the next thing we see is Regina Nicholas is in a dominant position, leaning over Officer Medina, appearing that she's going for his gun, and she's shot. What's the next thing we know? We know then Officer Loving is shot in the neck, and he goes down. And within a matter of seconds, Gerald Goines, who never shoots anyone, who doesn't have his gun in his hand, goes into harm's way at the breach of the door to extricate Mr. Lovings, and Gerald gets shot in the face. Okay? Now what else we know? We know then shortly thereafter, Sergeant Reyna goes to the door trying to get Mr. Lovings, who's been, according to Ranger Wolf, incapacitated, gets him up to move him away, and Reyna says, "I'm looking him eyeball to eyeball, and I'm thinking I'm getting ready to park it. My life's getting ready to end." And Dennis Tuttle shoots him in the face. Remember Sergeant Reyna walking down the street later on, talking about that crazy old man was laughing at us. When he was shooting at us. And then they didn't want, well, who could he possibly be talking about? You know who he was talking about. Officer Rios knew who he was talking about. What does that have to do with anything? You have to consider the facts of the case. It's not, I'm sorry, it's a tragedy when any human being dies, but in this case, on these facts, it is not a grave injustice. It simply is not. And the judge explains that to you in her charge. I'll get to that momentarily. One thing is clear here, no other officer besides Gerald had a clue that the search warrant was bad. They basically stipulated to it. They're not fighting us over that issue. Not one of the members of Team 15 had any knowledge the search warrant was bad. Why is that important? Because what the judge tells you with respect to the law, that even if the search warrant is bad, but I don't know it's bad, and assuming I announce my presence and my intentions, then I have a right not to be assaulted by the homeowner, even though I shouldn't be in the homeowner's house. So what happens after that? We know what happens after that. The first shot is at a dog. The first shot at a human being is by Dennis Tuttle, who shot and aimed and fired and hit and aimed and fired and hit and did it ad nauseum as he marched to the light of the open door, shooting people in the face. And they want to contend, oh, these homeowners had no clue who was there. Right. Reagan, let's go to the first slide, please. So here you go. The critical inquiry for you to make is, did Gerald Goines cause the complainant's death by committing an act clearly dangerous to human life, causing armed peace officers to make forcible entry into a residence through the use of a no-knock search warrant based on false information? The answer to that question has to be no. And why is that? Because serving the warrant didn't cause anybody's death. Search warrants, including no-knock search warrants, are served every day without incident. By entering the residence, even on an invalid warrant, that didn't cause anybody's death. Entering without knocking didn't cause anybody's death. What caused someone's death? What caused someone's death is Dennis Tuttle and Rosina Nicholas not complying with the officer's directive. That's what caused their death. They didn't get blown away because, well, I told you to do something, you didn't do it. It's not as simple as that. They certainly didn't get killed because of Miss Nicholas's profanity. But you have to understand everything to put this in proper context. So let's go to the next slide, please. So, Her Honor tells you that you must find beyond a reasonable doubt that the result of the death of Miss Nicholas or Mr. Tuttle would not have occurred but for the defendant's conduct, specifically committing an act clearly dangerous to human life, to wit, causing armed peace officers to make forcible entry into a residence through the use of a no-knock search warrant based on false information, operating either alone or concurrently with another cause, unless, and here's the point, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the defendant clearly insufficient. If you do not make such a finding beyond a reasonable doubt, you are required to find the defendant not guilty of felony murder. So in our case, what is the concurrent cause? Because again, I can have a search warrant, and it can be as illegal and invalid as they come. But by me coming through the door, that doesn't cause you to die. There's got to be something else that causes you to die. Well, theoretically, I could come in as a police officer and I just blow you away. Well, I guess I caused you death then. That's not what the facts here are. These officers didn't fire upon anyone until they were fired upon themselves. So what is the concurrent cause that actually resulted in the death of each of those two individuals? Next slide, please. The concurrent cause, the actual cause of the complainant's death, was Officer Frank Gallegos' lawful and justifiable act of shooting both complainants because they both posed an imminent threat to the officers by their own conduct. That's what the evidence shows. I'm going to come back to Officer Gallegos, and I'm going to take you through again evidence that the only reason you heard it was certainly not because they brought it to you, but because of the confrontation clause and the cross-examination, you got to hear it. So let's rewind the video and let's go through the scenario. We start with the tactical meeting. The state has intimated that this brief meeting before the warrant was somehow deficient, but besides the fact that I really don't think that's a fair characterization of the evidence, that doesn't have anything to do with causation. Whether they had a hour-and-a-half meeting or a 20-minute meeting, it doesn't have anything to do with the actions of the complainants against the police in this case. So, according to Officer Rios and Officer Bryant, the tactical meeting that took place before the search warrant that was served was like any typical tactical meeting. Now, you may not like that meeting. I don't understand it. That's not what I do for a living. You might think, well, you think they would, have a lot more information, or they would ask more questions, or they would spend more time. At least according to Officer Rios and Officer Bryant, their witness, that's pretty much the way they go in every case. You have two supervisors who were present, who voiced no objection to the plan. The officers were informed by Gerald that the suspect in the residence, in all probability, would be armed with a semi-automatic pistol that he carried on or about his person. I think that's important, quite frankly, with respect to the other officers. Did they just go in there blindly and not have a clue that they were getting ready to go in harm's way? Is that really fair? No. They all knew, based upon Gerald's statement, that this guy was, in all probability, not only heavily armed, I think with a 9mm pistol, but that he carried it on or about his person. So they knew that going in. They also knew there was an aggressive dog. That wasn't a surprise to them. That was disclosed to them. Officers did not see a tactical plan. They established that. But then we were able to establish, according to Officer Lovings, that it's very common and not unusual for there not to be a tactical plan that is showed. So now I want to talk about announcement, identifying as police, and warrant. And let me set the stage here. Announcing police and warrant, why is that important? Because as you heard in the jury charge, there's explicit instructions for you with respect to what we call the law of justification. In a nutshell, officers in this case, on these facts, were fully warranted in the law based upon the facts to shoot both of the complainants in the very manner that they did.
Objection to misstatement of the law, Judge.
Let me back up. I don't believe it's a misstatement, but let me back it up. Is that in order to be justified to be present in the location, you have, I'm going to put the slide up and I'm going to show you exactly what Her Honor has said. But we also talked about this during jury selection, is that you need to announce yourself as to who you are, and you need to announce why you're there. The law requires that. But let me tell you about a charade that started early on in opening statement by the prosecution. And the reason it started is they're definitely afraid of justification in this case. They're running from it as fast as they can. Because when you find, and I think you will, that based upon the law of justification, the officers were justified in the way they responded to the imminent threat, they're out of court. They're out of court in this case. Because if the officers acted justifiably, if they had the right to shoot Miss Nicholas and Mr. Tuttle, which we believe the evidence clearly shows, then that establishes that the cause of the death of those folks was Officer Gallegos.
Objection to misstatement of the law,
And,
Judge.
and
Ladies and gentlemen, again, as I said before, the law that's in this case is in this charge. Whatever the attorney says is their interpretation of the law.
I believe, based upon the jury charge in this case, you all get to read it, that if the officers were justified in shooting Mr. Tuttle and Miss Nicholas, then by definition, that is the concurrent cause. That is the justification to cause their death. I'm sorry they're dead, but that is the reason that they died. Again, Mr. Tuttle and Miss Nicholas did not die because there was a bad warrant and the officers came in the house. That didn't kill anybody. It's what happens in response to the officers in the house. But let's talk about why I believe the state is definitely concerned about us establishing, although we don't have the burden of proof, but us establishing based upon the evidence why the entry, or why the officer's conduct was justified. We put up what Mr. Force said in the opening statement. Not one of those officers was announcing that they were the police. Not one of those sirens was on. There was no mention of a search warrant because Case Agent Gerald Goines specifically directed this warrant be executed as a no-knock search warrant. Not one of those officers was announcing they were the police. Absolutely wrong. Absolutely wrong. He got caught. And who caught him? The evidence caught him. And he talks about manipulation. Really? And the charade by the prosecution continues. You listen to a version of events on direct examination, and this is the version they put out. And then when it's our turn to ask questions, you get to learn something totally different. Let me take you through this. Morales, Officer Morales. Remember, body worn camera? He was running up the east side of the driveway. Direct examination. He didn't remember anyone announcing police search warrant. Then the state played his body worn camera footage for you to hear and ask him, can you hear anyone say police search warrant? And of course he says no. They proudly stand up and say, pass the witness. Well, what do you learn on cross-examination? He provided a sworn, written statement to the Special Investigation Unit within hours of the event and clearly told investigators under pain and penalty of perjury that he did hear an officer identify themselves as police and said search warrant. That's what he said on cross-examination. He agreed with my demonstration that it would have been yelled out and yelled out very loudly. That clearly happened in this case. They hate it. They like to crawl under their desk right now. They hate that because, again, when you look at the justification language in the court's charge, once you identify yourself and once you state why you're there, then if it's objectively reasonable based upon the facts, the officer is entitled to use force and deadly force if necessary.
Object to that, Judge. That's a misstatement of the law. Can we at least have him instructed on the entire law, Judge?
So he acknowledged, Officer Morales acknowledged that the body-worn camera audio did not activate for the first 2 minutes, which is after the announcements and after the entry with the Moby were made. You know, I could forgive him for not remembering that because it's been over 5.5 years and God knows how many other scenes he's made. But those guys right here, they knew what he was saying all along. They had his statement. They would just prefer that he not remember because that's a critical fact that eviscerates their theory of this shooting in the case that it wasn't justified. Let's go to the next witness, Rios. Same thing on direct. DA's played the body-worn camera tape and asked Rios to listen to your body-worn camera. You hear any officer announce their presence and intentions? Police, search warrant? No. Pass the witness. What do you learn on cross-examination? Number one, you learn that the camera's audio doesn't kick on for 2 minutes. You also learn that he didn't turn it on. He turned it on late because he's running and fidgeting with his camera. And you also learned in the cross-examination that he didn't get to the location where he was when he started hearing shots. He was the last man to arrive. He was the third vehicle back. He parked in front of the third house away to the east of the 7815 Harding Street location. So by the time he finally got up to the perimeter where he was supposed to be, guess what? They've already announced, they've already entered, and that's demonstrated by Defense Exhibit 104A and B. Let's look at 104A. Remember this? That was brought out on cross-examination. So even before his body-worn camera audio comes on, and as he is finally getting to the yard after parking his car and boogieing down the street, look at that. The door, that white door is not black. That door appeared black because obviously it's already been breached. They've already announced their presence, and now they're already going in. So this business about listen to your tape, what do you hear, when in fact you learn that the tape doesn't come on for the first 2 minutes. That's not fair. Could that be manipulation? You know, I think the saddest example is their witness, Bryant. And maybe not only sad, maybe a bit disturbing, because the state put him on and asked him if he heard announcements made upon entry, and he said that he thought he had, but after the DA's office played the body-worn camera footage for him when they were preparing him to testify, and he didn't hear the announcements, he started doubting his own memory about it. Of course, the body-worn camera footage that the DA's office gave him to listen to was the very recording that didn't capture sound for the first 2 minutes. And they intentionally did not tell him that. That was not his body-worn camera, of course, because he didn't wear one because he's a narcotics officer. So they left him with an erroneous impression and put him on the stand to testify about that, where, well, I just questioned my own memory. I thought I heard it, but I don't know. I guess I didn't. When they're sitting on his sworn, written statement that he gave to SIU at 12 o'clock in the morning, and we're going to visit about that in a second, that statement clearly showed that he said that he heard someone yell police and warrant as they went through the door. Why would they keep that from you? Why don't they want you to know that? Let's talk about Ranger Wolf. Ranger Wolf confirmed that in his review of all the material that he got from the gatekeepers over here, that he closely examined the physical evidence at the scene, including photographs, videos, body-worn camera, lab reports, ballistic reports, autopsy reports, and then conducted his own trajectory analysis. And what did he say? Remember, he said that physical evidence doesn't lie, and what he also said on my cross, that the physical evidence was consistent with the officer's accounts. And that's what he does. I mean, he's not there. He doesn't know what happened any more than you all do. But whatever happened in that 80 seconds, the officers thereafter give sworn, written statements under oath. And they give them at a time when they don't have a clue what the forensic types are going to dig up with respect to the evidence on the scene. And of course, they don't have a clue that the DA's office is going to request that the Texas Rangers themselves ride into town and conduct their own investigation. They don't know what's going to come out of that. So what comes out of that? He does his trajectory analysis, and he says, based upon everything I know in the case, and especially based upon what I have done in the case, the shooting trajectories are consistent with what Officer Pardo and Officer Gallegos is saying with respect to the shooting of Miss Nicholas. How is it consistent? We know Miss Nicholas is in the southwest corner of that living room. We know all of her personal stuff is right there. Her dope pipe, her dope, her cigarettes, ashtray, her house shoes, everything's right there. And the evidence in this case is that's where she's located. And that's when she stands up and starts throwing the MF bombs, that's where she's located. And then that's when she turns and is facing toward the door, and she's in a position where it appears she's reaching for Officer Medina's shotgun when Officer Gallegos is on the right side of the porch stoop. The door is wide open. He can see that occurring, and he fires. All of that is 100% consistent with the physical evidence, with the trajectories. Thank you. Remember, I asked Ranger Wolf what he relied upon. What information was there you relied upon? Well, everything I mentioned, 200 plus pages of offense reports, witness statements, recordings, yada, yada, yada. I also listened or considered the sworn and written officer statements, because obviously in the course of my investigation, got to know what they say occurred. And so we brought to your attention the underlying basis and the knowledge that he relied upon. So we have Steve Bryant. Entry team entered the location led by Officer Medina stating police search warrant. All of this, remember, these statements were not admitted into evidence, but I was permitted to ask him specific questions as to what he relied upon. And what I'm providing, and I'm not going to go through all this, it'd take all night, but you will recall that I brought to your attention through him that in fact virtually every one of these officers confirmed that the police did announce themselves, and they did say warrant before they went in. Sworn testimony via these witnesses. That's what they said. They don't have to like it. I don't really care what they like, but that's what it is. And isn't it a shame that you didn't hear from, this wasn't brought out in their case? See, they don't want to talk about the circumstances surrounding the 80 seconds because it devastates them. It eviscerates their very lame causation theory that somehow, some way, by making false statements on a search warrant and ultimately sending armed police officers to that location, that caused the death. That didn't cause the death. I would say the false information in the affidavit caused the officers to go to that location. But what happened after they arrived is a separate analysis. We discussed this in jury selection. And the judge tells you in the charge. What you ultimately have to decide is, has the state proven to you beyond all reasonable doubt that it was the defendant's conduct that caused the death? We say they have not. The death were caused independently, if you will, by the unlawful conduct of the homeowners. I don't get any joy by they're deceased. They can't speak for themselves. I don't get any joy in that. But the reality is what the reality is. It's just simply uncontroverted. Even Texas Ranger Wolf told you that. The first person who shoots a gun at a human being is Dennis Tuttle. Nobody shot at Dennis Tuttle until he started putting bullets into people's faces and necks. That's what happens in this case, and it happens quickly. That's indisputable, indisputable. And under the circumstances, I'll get to that in a second, deadly force was appropriate. Once you start shooting an officer, you have a right to arrest that person, and maybe before you arrest them, you're going to blow them away. Because if you don't, you're going to have another officer shot in the neck, shot in the head. Officer Pardo, I asked Ranger Wolf this very question. I then looked over to my left, saw Officer Medina lying on the couch. This is exactly what I asked the officer to testify about. What I asked him is this specific question. I asked him what he saw, what he relied upon, and Ranger Wolf said, I then saw the female to be standing over Officer Medina while screaming at him in an aggressive manner as he attempted to cover his shotgun with one arm that was hanging from his chest. That's the specific question that I asked Ranger Wolf on the witness stand. And then we get to Officer Gallegos. I asked him specifically what did he see with respect. I asked Ranger Wolf what was it in Officer Gallegos' statement that he relied upon regarding the sequence of the shooting event. And I asked him this specific question, what did Officer Gallegos indicate he was able to see before he shot Miss Nicholas? He said, with Officer Lovings lying in the doorway.
Judge, this is still a document, not an evidence.
This is exactly what I asked him, Judge.
I'm not going to argue with you, just please, in your closing, do not read straight from the document that's not an evidence.
What he said was that he saw her, Officer Gallegos, saw Miss Nicholas in a dominant position yelling, motherfucker, and it appeared to be attempting to grab Officer Medina's shotgun, and Officer Gallegos said in his sworn statement that he was in fear of his life and the life of his officers. Now, they don't like it, but that's what the evidence in the case shows, and that shows exactly what Ranger Wolf relied upon in part in conducting his investigation. How much time have I used, Your Honor?
Over 9.
I'm sorry, how much?
You are at 39 minutes.
Thank you. Thank you very much. I contend it's a canard on the part of the prosecution to contend that these homeowners must have been startled and they didn't know that the officers were law enforcement officers. And then they played the, oh, there's not a lot of light in that house. Well, I don't know about that. None of the officers ever indicated that they had any trouble seeing. But if you're shocked and you're surprised, does that cause you then to take steady aim and shoot people where they don't have any body armor, where you're able to hit people in the neck and the face because you're startled and you don't know what's going on? Does that make any sense? Because you're startled and you don't know what's going on, that makes you go toward an officer that has been injured and then reach down and try to grab his shotgun? Is that the normal response from somebody who is shocked and amazed and doesn't know what's going on? Quite to the contrary. That shows free volition on their part. It shows they know exactly what they're doing and they put themselves in harm's way. I mean, are you shocked and amazed when you shoot somebody in the face and you laugh about it? That comport with your common sense? Guess what else you got to learn on cross-examination? Not only were all those officers in that house, not only were all of them not criminally charged, but on cross-examination, you got to find out that Detective Lujan, that poor guy that had to endure lawyers for 3 days, on the witness stand, what do you learn on cross-examination? Based upon your exhaustive investigation of this case, did you find any evidence that any of the officers used unlawful force during this shooting incident? Here's the guy that was in charge of investigating the shooting incident. You don't hear this on direct, but on cross. And what did he say? We learned of no evidence that the officers used unlawful force. Well, why didn't they bring that to you? Let's go through quickly the slides about the use of force from Sergeant Guerra. Remember Sergeant Guerra? He was here. This is questions I asked him. This is what he said. The use of force is justified when there's an imminent threat, meaning that the person has the perceived ability, opportunity, and potential intention to cause harm. The threat must be real or reasonably perceived to be real. Next. Any use of force should be evaluated from the perspective of a reasonable officer present at the scene rather than through hindsight. The reason for this approach is due to the fact that officers often have to make quick decisions in high pressure, rapidly evolving situations.
Judge, I'm going to object. This is not a law that's in the charge that's for this jury to consider.
This is exactly his testimony, Judge. Thank you. While it is important for officers to respond to imminent threats, they do not have to wait until the threat has fully manifested an attack. Someone who poses an immediate threat to an officer's life can be met with immediate lethal force.
Objection, Judge, there's more to that law than just that.
He said, can I continue? He said shooting a gun at an officer and attempting to go for an officer's firearm after the officer has been shot both pose an imminent threat to an officer's life and can be met with immediate lethal force. And that determination often has to be made in a millisecond. Who told you that? Their witness, Sergeant Guerra, their expert, Sergeant Guerra. But interestingly, once again, you only learn that because of our right of cross-examination. Let's go to the 951 slide, and then I'm going to stop. I'm not going to read all this to you folks, but I ask that you all read it carefully. I know you will. This highlights when, in fact, an officer is justified in using force or deadly force. The judge has given you that, and the judge says that if you find those factors to be present, she's instructing you that you then find in Gerald's favor as to that issue.
Ladies and gentlemen, you guys will get a copy of the charge. That is a law after the charge. What the specific instructions are in that charge.
She says right there, if you find those factors, you will find for the defendant on the issue of a peace officer's justification of use of deadly force. And guess what? The state has the burden of proof in all criminal cases, and the burden never shifts to this lawyer. I don't ever have it. So what do you have? Let's wrap it up in a bow. You've got Ranger Wolf, who says that the officer's statements are consistent with the physical evidence. You have Sergeant Guerra that tells you under what circumstances in a very fast-moving, tense situation can officers reasonably and legally respond, and you have finally Her Honor laying it out for you for your consideration. I want to say one more thing, and I promise, Nicole, I'm going to sit down. Mr. Tuttle's sad psychiatric situation doesn't absolve him here. I'm sorry. You can imagine this gray hair, how many people I've represented in this community my entire legal career, and I've represented famous and wealthy people, but I can assure you the vast majority of my clients are not that. I represent the common man, the common woman, and it's been my supreme privilege to do so. And I'm sorry for him, but his antipsychotic or his unwillingness to take his antipsychotic medication, I'm sorry, that's on him.
Objection to facts, not in evidence.
In fact, they're all in evidence. The medical records are in evidence. You notice once again, the gatekeepers over here used Texas Ranger Wolf to talk about Mr. Tuttle's records that Ranger Wolf, had never seen. I've never heard of such a proposition. Those records are in evidence, and Nicole will talk to you about some of them. But they're riddled with entries about psychosis, that he's on antipsychotic medication, that he's not a good historian, he doesn't provide accurate information, and that he says either I don't own any guns, or he says my guns are locked up, okay? So I'm sorry for him, I'm sorry for the family, I'm sorry for that tragic situation, but that doesn't absolve him. That doesn't give him any license, any right to methodically, intentionally shoot officers. You notice what Ranger Wolf said? After he started firing, and we have evidence that he was holding the gun with two hands because you get a better shot, and you pull that trigger back and you have less pounds of pressure, so you get a more accurate shot. He's not running, hiding, seeking refuge. He's marching. He's going forward. He's going forward. He's coming forward. He's shooting, and what's at the door? The light of day. So this business about he couldn't see and he didn't know, that's just not fair. All right. These folks would not have died but for their unlawful acts and conduct. You can hate Gerald, you don't have to like false statements, and he can be dealt with in other ways, but he's not guilty of murder under these facts. Thank you again for your time. Thank you for your service. Thank you for your attention. Thank you for your commitment to our criminal justice system. And just on behalf of this lawyer, thank you for letting me have the opportunity to present my defense.
The narrative manufactured by the district attorney's office for the last 5 years, right down to the very last days of trial, is a fiction. For 6 years, almost 6 years, this district attorney's office has had the ability and the responsibility to investigate, to talk to witnesses with firsthand knowledge of the events, and to decide what charges would be appropriate to bring in this case after doing that. And they elected sometime in 2020, early, to charge Mr. Goines with murder. That is not the correct charge. We can guess and we can wonder at why they didn't want to talk to their witnesses, why they didn't want to go through the information they had at their disposal, and we can guess at why they decided to present the facts to you in the way they did, even starting on the first day of trial. The DA's office now wants to tell you there's nothing to see here. Look over here. Suddenly, the multitude of misinformation and opening argument from this district attorney's office is not what they want you to look at. We didn't bring it up. They did. Why? I would suggest to you it's because of exactly what Mr. Seacrest has spent a lot of time going through, and you will have in the back with you, each a copy, as the judge has said, the problems they know lie in this document. And this document are your jury instructions about what constitutes causation. And by pulling at your heartstrings, they're trying to make you mad at Mr. Goines. Maybe they're hoping that they can distract you from what happened and what that causation was on January 28th, 2019. So let's talk about some of the things that you heard after all these years and the choices to charge this case. And when that choice is made, the district attorney's office is telling the public that they understand that they have the burden of proof to prove everything that they alleged beyond all reasonable doubt in that filing. And what you heard in the materials that they told you they were going to prove to you on the first day of trial, they implied that Ms. Garcia's 911 call was wholly unsubstantiated. You've now heard the evidence about what was going on in that house. They told you there was no investigation into this case, and we're going to talk about that in a moment. They told you that no police officers announced anything as they were using that Moby, either in that immediate time frame right before or right after. No one did that. And we know that's not true from the statements of the people that were there. Information that they had access to from the beginning. They told you, or implied, that somehow a no-knock warrant is less safe for everyone involved. What do we know about that now? Through the experts, it's exactly what makes it safer when you know that the individuals in that location may be armed with a weapon. And we're going to talk about that from the evidence that we've learned from the witness stand through the witnesses. They told you, continue to tell you right through today, or imply, that officers just showed up at that house and started shooting at random for no reason. That's not what the evidence showed that you heard in this trial. And they had access to it. All those statements, all the first-hand accounts of the people that were there, some of whom they just chose never to talk to. In almost 6 years. They told you, or implied, even today, and I think the words were almost exactly this, that something that those officers did on the day they served that warrant by shooting to save the lives of other officers was somehow not justified. And you know from their own experts that is simply not the case. Same experts that they've had at their disposal for all these years. They told you in opening that Miss Nicholas was shot where she lay on the couch. We know that is not true. They told you that Squad 15 somehow behaved in a way that was inappropriate. We now know from every single witness called in this case that that is not true. They told you that it was simply too dark to see in that residence. And we're going to talk about all the ways we know that's not true. And we've taken some time, and it took a while, but to map out the front of this house all the way to the bedroom door so that you can see for yourself exactly where things happen. We're going to spend some time, not much, going through what that looks like in this physical space. They told you repeatedly. They're the ones that started this conversation, and they did it through their very last witness, bringing it up themselves, insisting that Nicholas and Tuttle were not drug dealers. This is not us trying to bring up some sort of a character flaw. This is us trying to dig for the truth so that you, as you decide whether or not there is the causation that they have to prove and whether or not the facts and the allegation that they lodged, that they chose to be able to bring you the proof about beyond all reasonable doubt, exists. They started this conversation. They even went so far as to tell you through various witnesses, not in direct in opening, but later on, and we'll talk about this, that there was no scale in that house. They told you in opening argument, and I think the exact words were, it was a lie that there was a white male in that home with what appeared to be a 9mm. And what did we find later? And we'll go through some of this stuff. Not a real gun, but if you're looking at state's own exhibits, 1513, 1512, and 1514 of the weapon, which you can see on your screen, that was found in the bedroom where they slept in shifts. It's a fake gun. I don't know about you, but if somebody pulled that out on me, I'd go the other direction. We also know, oftentimes, a real firearm is heavier than a fake firearm. They took great pains to make you think no such thing could have possibly existed because apparently Mr. Tuttle was wearing sweatpants, which couldn't have sustained that sort of a weapon. Never mind that the weapon that Dennis Tuttle chose to use, which he did have access to, and we're going to circle back to that too, on January the 28th, was a very large, very strong, very heavy 357 Magnum Colt King Cobra, which he did manage to get access to, or he had access to all along. Now, I want to go back to that 911 call. As we've talked about, you were told in opening argument by the prosecution, who has the burden to prove what they claim. Wholly unsubstantiated was the impression that was left. But we know that the caller told the police that there were a lot of guns in that house. What did we learn from the evidence? That's in fact true. We learned that the caller said they were doing drugs in that house and providing it to others. What did we learn from the evidence in this case? That is true. We learned from the 911 caller, the folks in that house are not going to cooperate with police. Guess what the evidence showed in this case? The 911 caller was right about those things. So what happens? You have patrol officers who respond because of the guns in the call, a code 2, I believe it is, to go to the location. And you watched Officer Nikki Blankenship Reeves come up and talk about the investigation that she began. She talked about the things that she looked for and tried to determine, and this came out through their witness also, that someone walked by as they were standing out there in the dark and said, oh, gosh, there's a problem at the dope house. The cops are at the dope house. And don't you know, even though they tried to imply through the evidence, oh, surely this was this 911 caller who had all of this bad information for the police. Don't you know that if it in fact was this 911 caller who they've identified very specifically now as a woman named Pat Garcia, they'd have shown Officer Blankenship Reeves a picture, or Officer Morales, a picture, driver's license picture of this individual, and says, is this the person you saw walking down the street who said this was a dope house? But of course they didn't, because it wasn't her. It was someone else in the neighborhood who also knew that unfortunately this was a dope house. This is evidence they elicited from their witnesses. This is not defense cross-examination. You also hear that based on the call and what they observed, Morales and Blankenship Reeves were concerned enough that they wanted to alert an actual narcotics lieutenant. Now, there was a little strangeness that for some reason the state didn't initially want you to know that the lieutenant that Blankenship Reeves alerted was her life partner. That's fine. This is still someone who they contacted and asked, how do you spell heroin? Let me tell you what's going on. And together, this experienced narcotics lieutenant and these two patrol officers who had already begun an investigation by responding to a 911 call with things we know contained true information, they went and did further investigation at Lieutenant Todd's direction. They gathered information about what was going on at that house. Now, this may not be the way Officer Blankenship Reeves is supposed to file a supplement, State's Exhibit number 10, but it is a documenting of the investigation that Officer Blankenship Reeves conducts at that location. We will never know about the back of that page, because when, as Lieutenant Todd requested, Officer Blankenship Reeves and Morales make sure that they're providing her with these field notes, Lieutenant Todd sends it as a text message and assigns the case to Gerald Goines. She doesn't want you to think she's assigned anything for some reason until it comes out that this was sent with a very specific text message to Gerald Goines. He receives the investigative information. Lieutenant Todd doesn't ever bother to get a knock number, which is the way that we heard you make sure if you're in narcotics and you're giving out an assignment, maybe that's why she didn't want it to be an assignment, that you avoid deconfliction. Essentially, you don't want officers ending up at the same location, someone making a buy who's also another officer doing something, or worse, shooting at each other, right? That didn't happen. She didn't, as a narcotics sergeant or narcotics lieutenant, actually higher than that, ever even get a knock number. We know that Gerald Goines did get a knock number because he had been assigned this investigation, despite the fact that she claims she didn't assign it. Now, we know from that investigation that they were able to determine the names of the residents in that location. Why would Gerald Goines need to determine that again? It's already been done. It's part of the investigation provided to him by Lieutenant Todd. They can see that there is information about a Wayne Osborne connected with that residence as well, who is a white male. You are able to see exactly what kinds of things they did, and we can go from the investigation to ultimately one day there's a briefing, okay? Now, I want to stop here because there is something that we definitely want to come back and talk about, and that is this series of questions that you're going to have to go back and take a look at in this jury charge instruction about search warrant affidavit, and there's been a lot of misstatements. And keep in mind, this is relevant to your consideration as jurors because the state holds the burden at every single stage, whether it is to prove the very original charge that they accused Mr. Goines of, which is murder, all the way through any iteration of any charge that you see in that jury instruction, all the varied tampering with the government record instructions. Their own witnesses on multiple occasions, because it's a casual way of speaking down at the courthouse and in law enforcement community, no doubt, conflate the words search warrant and affidavit. But you heard through multiple witnesses these are different documents, okay? And that's important because if the state wants to get a conviction based on, as they've alleged in their felony murder indictment, never mind the causation problem that we have to get past, and you cannot get past that, they have to demonstrate that it's a false search warrant. But as you know,
That's a misstatement of the law.
Again, ladies and gentlemen, the law that's in this case is in this charge.
read the charge. It says search warrant. I challenge you to find anything in that search warrant that is false. It is a document which does not contain a narrative of the facts. It is issued by the judge. The judge puts the date. And I would suggest to you the reason for that particular section of the law is to make sure you don't have an officer that tampers with the date or does something or fakes a judge's signature. I mean, there could be a multitude of reasons. But I challenge you to look at that search warrant and find in the search warrant a false statement by Judge Markham or a repetition of a false statement made by Gerald Goines. Now, circling back to the affidavit, we've told you there's not a CI. You have to make a decision about, and we're going to talk more about how that particular matter comes to play here. You have to make a decision about whether or not the fact that there's not a CI matters at all to why those officers are in that house or why that investigation is being conducted or as to why shooting began. And I would submit to you it does not. So let's circle back to that in a little bit. Let's talk about that briefing. At the time, Officer Goines was a police officer. He goes and gets this search warrant. He goes and he sets up a briefing. Pretty standard briefing. Nothing about this briefing, as you've heard from all the evidence, is anything other than totally standard. At this briefing, where he shares information about the investigation that started with Blankenship, Reeves, and Morales, and Lieutenant Todd. He gives information to the officers who are there. Several of the officers, and there's some question as to whether it's 2 or 3 that came out in evidence in this trial, actually conduct their own independent surveillance, which is something else the state wanted to suggest never occurred. It may not be the type of surveillance that you would see in a case where you have somebody moving kilos upon kilos of cocaine, but these are different kinds of dealers. This is as I believe Officer Frank Hasselberger testified, a getting high on your own supply situation. And so surveillance in that case is exactly what these 2 officers did when they did that drive-by surveillance to examine the location, make sure they understood what they were going into. You also know from the briefing that was provided that he attempted to use the whiteboard or whatever the electronic board was to give information about the location, but was able to do so without that equipment working. We know that there was a vicious dog that they were very aware of at the premises, and that turned out to be true. And by the way, we know from the state's very first witness, Sarah Sanchez, that there was indeed an aggressive dog at this location. In fact, the dog was so aggressive that it once sent Dennis Tuttle to the hospital. Their own dog, or not to the hospital, they had to decide whether or not to send him to the hospital, but they believed he should have gone to the hospital from what happened with this dog. You also know from the various text messages that later we're going to talk about again, that Regina Nicholas has to tell people who are coming over to the house to purchase drugs, the dog is up. It's the same dog she brings with her, according to those text messages, if she's going out of her neighborhood to sell drugs to somebody else. That's the dog that Gerald Goines knew was at that residence and that those officers discussed before they ever set foot on the property at 7815 Harding Street. What else do we know? That they were talking about several potential suspects in that house. In fact, we know, even though we don't have the back page of that supplement that was never entered by Blankenship Reeves or Lieutenant Todd, that the officers who ultimately, and the 2 sergeants who approved this tactical plan and went on this search warrant, that they knew that there could be 2 white male suspects in this location, a vicious dog, and a man who was known to carry a gun everywhere he went. These officers all knew that when they went to that residence, they could expect to encounter immediate danger from an armed suspect. We know about the 3rd suspect, which was discussed because SWAT was called to the scene and no one could get entry into that residence even after the shooting took place until SWAT was convinced, which is why the windows are broken out, and you can hear on the exhibits admitted by the state, they're calling out, trying to calmly get this 3rd individual to come out of the house. All right, I'm going to circle back to that 3rd individual in just a moment. Now, they go into the briefing, and they ultimately are in the house. And I'm going to get Corey, who's been peacefully standing back here, so our mannequin does not fall over. And I'm going to move this, hopefully not break it. And I'm going to tell you on this, you can't see over the edge, I am standing by the front door. I am in the threshold of the front door on this diagram that Mr. Wynn took the time to draw. You are on the porch, okay? This is how close I am in the threshold of that door to you. It's daylight, and if I back up to about where that door would swing shut, I'd be about right here. This is what the officers could see. This is at some point what Mr. Tuttle sees as he's firing one of his 4 rounds into the face of officers dressed like this. Okay? But before we get to that point, we're going to turn this officer around, because this, for now, is going to be Officer Medina. And right here is the couch, based on the measurements provided on the diagram from the experts in this case. And Medina ends up about where you're seeing this evidence here. Now, he sees on this L-shaped couch a woman who is now screaming MF, MF, MF at these officers who are right there by that front door where that podium is. She is this close to this uniform as she's screaming MF, MF, MF. And you can turn them around. Meanwhile, Mr. Tuttle, we're going to talk about this in a minute, who has averred to medical doctors that he has no access to firearms, comes out from behind a wall and takes a tactical stance and manages to hit Medina in one of the only small gaps where there is no body armor. Now, Corey, if you wouldn't mind turning our officer around. Take a look at the incredible accuracy of that shot. He has to get that shot in between the protective plate on the shoulder and the protective chest plate to create the through and through wound that we heard Officer Medina had from the distance that you just saw across the couch, where his wife is now getting up and screaming at the officers, cursing. Medina goes down on the couch, and I don't think our friendly mannequin here bends over very well. He is, if you can envision it, right here in the middle of this table. What does Miss Nicholas do? We know from the evidence, she gets up as she's screaming and moves toward the officer who is now down on the couch to gain access to this officer's weapon, if you turn it around, which is strapped across his chest, where he is marked with the words police from every angle. And all he can do is take his good arm and try to cover it. Meanwhile, from about where you all are and Officer Maldonado are sitting, we have Officer Gallegos, who sees this going down from outside in the yard. And he has to make a decision right now. Do I let this MF screaming suspect who is approaching Officer Medina take his firearm and kill him? Or do I have to do what nobody wants to do? He shoots her. And we know where she is based on Detective Wolf's, Ranger Wolf's thorough investigation with the measurements of what went on in that house. We know from the entry wound that what the officers said they saw is so, but we're not done yet. Now you have an officer, and you can move our mannequin over here, coming in the front door from the porch. Now you can turn him around. Tuttle, who has made the decision to successfully fire off a shot through a small gap in Officer Medina's body armor, continues his calculated trajectory toward the officer entering the front door. You can turn back around again. The open front door. This is what he sees. And he shoots again. This time, landing, and these guys have helmets on, a space this big. Now, even some of the officers, and you heard from Blankenship Reeves that some of them had a balaclava on, up, which may conceal the face, but it also makes it more difficult to figure out where to hit flesh. Tuttle didn't have a problem. He took Lovings down, who falls into the doorway. Is he done? No. He is not complying with officers' commands at this time. While Lovings lay on the floor in a pool of his own blood, having been shot in about 3 inches worth of space, Tuttle continues to walk toward him, reaches down, grabs the firearm, which Lovings had been holding but can now not operate because he is paralyzed, and pulls so hard that the strap breaks. And you can take that evidence back with you into that jury room and take a look at it. But he can't get it off. Now we've got another officer coming through the door to try to save Lovings. Tuttle, standing in the open doorway as close as I am to you, looks at that officer and shoots him in the face. Goines tries to come in and pull his men out, never making it past the porch, never pulling a firearm into a position to use it, never discharging a single shot, only to rescue the fallen men, and gets shot in the face so badly that he goes unconscious and has to ultimately be taken to the hospital. We can take our mannequin away. This is what happened. This is what they did not want to provide a firsthand account to you about what happened in that house, because it belies the fact that Tuttle could see so well that he could place those only 4 shots that he fired into the flesh of the officers. That's how well he could see. What happened after we learned all of this horrific testimony from Ranger Wolf about what happened inside that house? The state threw a Hail Mary pass. The state said, we cannot have that testimony be the last testimony that you hear from Ranger Wolf. So what did they do? They took and used and manipulated, interesting choice of words, using years old records, personal records from Dennis Tuttle about nothing that had to do anything with 2019. They wanted you to believe, through what they put forth in those VA records, that this was somehow a veteran injured in combat. And I would submit to you that any service, combat or not, to the United States is a blessing and a gift to us all. But that's not what was painted to us. It was, if that didn't tug on your heartstrings, I can't help you. It tugged on mine. But it was a manipulation. It was another, don't look at the facts that we've raised. Don't look at the fact that we said in opening argument that the cops just entered and started shooting for no reason. Don't look at what the expert just testified. Be sad and really mad. But let's talk about what's in those medical records. What we know from January 25th, 2019 is that Dennis Tuttle had mood disorder and bipolar disorder with psychotic features. And he has some cluster traits. They tell him to continue to take his medication. Which also is with the antipsychotics. What we know from the autopsy is that was not happening, all right? We also know from January 25th, this is 3 days before this incident. Again, there's a borderline personality disorder that's referenced in there. Go one more slide, please. Patient reports access to a gun locked or in disuse. 3 days before, he is assuring his doctors, I'm taking my medicine and I don't have access to firearms. Patient declines participating in any additional groups at this time, and I believe there's one more. Per Dr. Sheff, under safety plan, access to gun in disuse, non-functional weapon. Thank you, Judge. He's again assuring the doctor he doesn't have access to a firearm. That's what's relevant here. He does have access to a firearm, and he's ready to use it. I want to try to wrap up here You've been so patient. And I want to hit a couple of more points about some things that you were told and why they're relevant. We have a circumstance where the state wants to bring in a bunch of things that happen after the information in the affidavit is long not considered anymore. The officers have entered, Dennis Tuttle has fired upon these officers, and they have been given no choice but to fire back. And Gallegos fires the fatal shots. Lieutenant Todd, who didn't file a supplement or get a knock number and claims not to have given any kind of assignment to anybody, suddenly appears at the hospital, maybe checking in on her friend, but she's actually doing some kind of an interview, which as a lieutenant in narcotics, she just elects not to record. And then she takes some pieces of paper while you'll have Gerald Goines' medical records. He is so full of fentanyl, medically given fentanyl for medication purposes, for the 9 surgeries that he had to have over the months. He can't even tear up a piece of paper. And she's having conversations with him that she doesn't record her side of, and we have some note that's partially torn up that has random words on it. That is not meeting the burden of proof for anything that's been charged, but it's not meeting the burden of proof that it even relates to what she claims it does. I suspect she had her own interests at heart. Then we have this allegation that somehow, over and over and over again, you're told that these individuals were not drug dealers. Because the state brought this up, they said it. They started the conversation. They did not want to call the actual narcotics officers who told you that they found heroin packaging in that house in those cereal boxes, which you'll be able to look at the exhibits and see for yourself, and in Altoids cans. Altoids cans came back to the DNA of Dennis and Regina Tuttle. Insists it's still not there. Insists the house was thoroughly searched. They didn't want you to hear from Detective Hewlin or Officer Hewlin, who explained to you why it was not possible or safe to search that entire house, but that she believed it was a house where drugs were being dealt, particularly heroin. We heard and we saw the pictures ourselves, and we heard from Frank Hasselberger about why that's a dealer's house. They didn't want you to hear from the narcotics officers who searched. They're the ones that brought this up and claimed it wasn't so. It goes to causation because it goes to tell you what these individuals, Tuttle and Nicholas, were thinking. I suspect they saw the police coming. She had been on the phone texting, as you heard from Joanne Nicholas, within 45 minutes of the arrival of the police, awake. We know that they slept in shifts. We know they had a dog to guard that they had to put away if somebody was coming over. I suspect they saw the police. He either had that gun on him or he got to it really quickly. That's what this evidence shows. The last thing, for whatever reason, they don't want you to hear from the lead. I'm sorry to tell you, Detective Emma Rodriguez came in and told you she was the lead detective. Maybe she wouldn't play ball with them. She was the lead detective on this case. She was the one that went through this phone. They insisted there was no evidence on that phone. In fact, they asked Detective Bass, who wasn't even the person who went through the phone, whether or not there was any evidence of drug dealing. He told you no. You heard for yourself, just in the month leading up to January 28th, after they brought the evidence out that it just wasn't so, that these people were dealing in all kinds of drugs. And by the way, where is Dennis Tuttle's phone? Don't you know we could have seen some interesting communications there? I don't know, and I also don't know what happened to the car that was in the driveway registered to the ex who is referenced as a supplier of drugs in multiple text messages that you will see in the exhibits offered into evidence. Wayne Osborne. Don't you bet that was an individual who was about 5'11", white male, known to carry a weapon? Finally, I'm about to sit down. I don't get up again. And the reason for that is that the state of Texas, when they make an allegation, has the burden to prove the things they charge and to prove the things they say. They are likely going to get up here after telling you all those things, an opening argument that just didn't pan out to be true, nothing to see here, nothing to see here, and why it's not relevant to causation. But you know that it is. And I'm going to ask you, since I don't get to come back up here, to ask yourself, if we had the opportunity to respond to those comments, what would we say? And just because they say it louder or more dramatically doesn't make it so. Ask yourself the detailed questions. Ask yourself whether or not they're just leaping to conclusions, trying to turn a search warrant into an affidavit or an affidavit into a search warrant, trying to say that everything in a document is false when you can read it for yourself. You're the judges of the fact, every fact in this case. And I don't know why the DA's office chose the route that they chose, but when they did it, they have the burden. Thank you, just briefly. You have an option to end this madness today. And that option is, when you go back into that jury room, to find Gerald Goines not guilty of murder, because he is not the cause of the deaths of Regina Nicholas and Dennis Tuttle. And I would submit to you that if you are mad at Gerald Goines, there are other consequences. And even ask yourself, the only possible other alternative is going to be in paragraph E and F, which are the attempted, I think it was tampering, and I don't have it right in front of me, but you will look for E and F of false statements in an affidavit, but you have to decide whether those, did they prove a false statement, and whether it was material to you before you would even go with E or F. We ask you to end this today. They have not met their burden. Find Gerald Goines not guilty.
I'll give you the 2 minutes extra that the board did. You have 52 minutes.
May I proceed, Judge?
Yes, ma'am.
It is offensive that 6 years later, 6 years after the fact, we are still trying to justify a falsified search warrant. It is highly offensive that we take the facts and the evidence and we twist them around as lawyers to justify a falsified search warrant. Now, I came here today with some prepared statements for you, but I cannot let what just happened pass. I've got to respond to what the defense attorney just did, what she just told you, how she just manipulated the facts, because I've seen you taking diligent notes. And if you were scratching your head saying to yourself, wait a minute, this does not comport with the notes that I took, then you're absolutely correct.
Objection, Your Honor, misstatement of the evidence.
Overruled. Please continue.
So let's set the record straight. Because after all, 6 years after the fact, 6 years after 2 people have died, 6 years after Gerald Goines falsified a search warrant, the only thing that this defense attorney can say about what Gerald Goines did in that investigation is call his name 3 times. I counted it. She talked more about what other officers did after Harding Street, after they went in and killed these homeowners, than Gerald Goines ever could do with this investigation. And why? Why didn't you hear her say Gerald did this and Gerald did that? Because he did nothing before they went in and massacred those homeowners. And let me be clear, We're not blaming the other officers. We believe that the other officers did not know that this was an invalid search warrant. We don't think that those other officers had any knowledge that this search warrant was false. I want to be very clear about that. And so the only person who's responsible for that volley of bullets is sitting here on trial named Gerald Goines. I will say his name. I will say his name loudly because the Tuttle family, the Nicholas family deserves it. I will say his name repeatedly because he's responsible for every single volley of bullets that riddled that house and that riddled those two individuals. I will say his name. What he did and what he didn't do. And what he did was absolutely nothing before they went into that home and massacred those individuals. Now let me respond to what the defense attorney said. Gerald Goines was full of fentanyl when we took his medical records, when Lieutenant Todd was trying to talk to him. He was so full of fentanyl, lying in a hospital bed. It just tugs at your heart, right? Well, first of all, they call that karma where I'm from, but that's not the message that I want to give you. Gerald Goines was not full of fentanyl prior to him falsifying that search warrant. He was not full of fentanyl prior to him lying to Judge Markham. He was not full of fentanyl when this defense attorney was standing next to him while he's lying in bed and he's lying.
Objection, that is a misstatement of the evidence.
And he's lying to Sergeant Bass. So if you want your heartstrings to be tugged, if you want to feel sorry for someone, I submit to you Gerald Goines is not the person that you need to feel sorry for. This defense attorney said the 911 caller knew more about the Tuttles, that she knew what was going on in that household. I agree with you. She knew more about the Tuttles than the supposed lead narcotics investigator on this investigation. I submit to you that she did. She knew what was going on in that house. At least she had some information. She knew more than what Gerald Goines did. But it is antithetical to common sense. It doesn't make sense that we're going to lump the 911 caller as part of this narcotics officer's investigation as if they were working together. Well, let me tell you something about this 911 caller. Her name is Patricia Garcia. And Patricia Garcia is the author of this travesty. And Gerald Goines becomes her editor-in-chief. Because the lies start with Patricia Garcia. And he picks them up and he writes the rest of the story of the Tuttles. And their story ends on January the 28th of 2019. It begins on January the 8th of 2019. It ends January the 28th of 2019. Now, the defense attorney also said the officers didn't fire. The first person to fire upon a human being is Dennis Tuttle. I want you to think about that. The first person to fire upon a human being is Dennis Tuttle. Now, I don't know about you, but if I'm laying on my couch, I'm not expecting someone to come in. I have every lawful right to a firearm. I hear someone kick my door in. My dog is barking, going crazy. I hear my wife screaming. I hear them shoot my dog. I'm in the back room and I'm coming around the corner and oh my God, they're holding my wife at gunpoint. Now they've shot my wife. Absolutely, I'm going to open fire before I ask questions. I'm not going to ask, hey, is this the police in my home? He's coming around the corner, as they so eloquently told us. He's coming around the corner. He can see his dog is dead on the floor. He can see his wife getting shot. So he's not going to come around the corner asking questions about who is this firing in my home. It doesn't make sense. It's a narrative that they want you to believe, but it doesn't make sense. And by the way, Dennis Tuttle has every right to defend his home. As he's coming around the corner, absolutely. First person that he's going to take a shot at is going to be the officer.
To the misstatement of the law in terms of right to use deadly force in this circumstance. So please continue.
First person he's going to take a shot at is going to be the officer who has his weapon trained on his wife. He doesn't know what's going on. And they talk about, oh, well, the doorway, there was so much light in the doorway. You saw the pictures in that house. They had every window covered, every single window covered before they were blown out with blankets, etc. It was dark in that house. I am not telling you that the Tuttles could absolutely not see, that they couldn't see in front of their faces. That's not what I'm telling you. But when you have someone who's coming around the corner, you know that your dog has been shot. The weapon is trained on your wife. You're going to shoot first, ask questions later. And you know who's responsible for that? This individual who falsified the search warrant in the first place. Now, did those officers then, were they justified in firing after that? Well, absolutely. They were justified. And you know who's responsible for that shootout? This individual who's sitting right here before you. And his name is Gerald Goines. And I call his name not to tell you that he was sitting in a hospital bed. I call his name because it needs to ring out for everything that he did, for every shot that was fired, for the 4 shots that Dennis Tuttle took in the protection of his home. He's responsible. For the 40-something shots that those officers took trying to defend themselves, he's responsible. He doesn't get a pass because his fellow officers, whom he lied to get the search warrant, got shot. He's responsible. Now, they talked about Ranger Wolf. Ranger Wolf told you from the stand he had a very limited purpose for what the district attorney's office asked him to do. And so on the stand, what you heard were questions from the defense about, well, let me give you this scenario. If this scenario were the case, what do you think about this, Ranger Wolf? He answered those hypotheticals correctly, based upon the investigation that he did. And then you heard from the state, well, Ranger Wolf, what about this set of hypotheticals? If this were the case, what would happen? And he answered those questions correctly according to his investigation. But let me tell you what Ranger Wolf never said. Ranger Wolf never said that he believed Medina, first person who's shot by Dennis Tuttle. Medina is over here on the couch by their own diagram. If this is the door going into the home, the couch begins here from this blue line. The couch extends over here and over by Mr. Forst. Now, hear me. If Medina is here on the couch, Rosina Nicholas would be shot where Keaton Forst is sitting. How is it? In what universe?
Incorrect rendition, misstatement of the evidence.
Gentlemen, you should remember the evidence as you heard it from this witness stand. Again, closing arguments are the attorney's interpretation of the law and what they need to do with it. Please continue, Ms. Petty.
In what universe is it that Regina is going to come all the way over here to where Medina is and try to take his weapon? They have to tell you that. They have to make it seem as if the Tuttles were doing something wrong inside their own home in order to justify this narrative that Gerald Goines didn't falsify a search warrant? Because the only way that they could justify that narrative that Rosina was trying to take Officer Medina's gun from over here is to say that, oh, well, that now they are trying to assault those peace officers. They're trying to disarm a peace officer. They're doing something else to a peace officer. So they were justified in getting shot. And it is ridiculous. The reason why it's ridiculous is this. Because Officer Wolf, Detective Ranger Wolf says from the stand, he does not believe that Medina was right here when he got shot and Regina is coming after him to get his weapon. Why is that? Because Officer Medina rolls towards the door. He rolls towards the door. And this is where the door is, where I'm standing. So that false narrative is just that. It's a false narrative to try and justify the fact that they want the Tuttles to be unjustified in using force. It doesn't make a lot of sense to you. I can see the puzzlement on your faces because you took notes on this part. We were watching you when Ranger Wolf made that assertion because it was contrary to what the defense was trying to get out. And remember, Ranger Wolf would not budge from that. Now, the notion that a no-knock search warrant makes it safer for anyone is a fiction from the defense attorney. What every law enforcement officer on this stand said is that a no-knock search warrant is inherently dangerous. And why is that? Because the homeowner doesn't know who's coming into their home. Because the law enforcement official may not know what's on the other side of that door. And it makes it even more dangerous when you do no official investigation, when you lead armed peace officers into a home, when you don't know what's going to happen on the other side of that door. That's what every law enforcement official told you. So the notion that it's somehow safer to burst in versus giving them time to get to the door is just ridiculous. We put on the Tuttle's Med Rex. We make fun of Dennis Tuttle because he's a veteran who has some mental health issues.
Objection. That is an absolutely inappropriate argument and a misstatement of the evidence.
Same.
Ask that the jury be instructed to disregard.
Disregard that last statement by the state.
Move for a mistrial.
Denied. Please continue, Ms. Mann.
Thank you, Judge. The fact that we're going into Dennis Tuttle's mental health records, his veteran records, his struggles after serving our country, you answer what the purpose of that is. What is the purpose of that? I asked a question way back when another detective was on the stand. They asked you, why is it that the state didn't call these 3 narcotics officers? And do you know what each of those 3 narcotics officers told you? Because what they did in their investigation had absolutely nothing to do with whether or not Gerald Goines falsified a search warrant. So they brought those 3 narcotics officers here to tell you what? That the Tuttles were dealing drugs? That Regina was dealing drugs? They put Dennis Tuttle's mental health records on trial for what? To tell you that he has mental health issues? But it doesn't go to why we're here. And why we're here is, did Officer Goines at the time falsify a search warrant? So those last 3 individuals that they called, we didn't call. We had them on our list. But after looking at our evidence, we realized they have nothing to do with whether or not Gerald Goines falsified a search warrant. And you heard each of them tell you that the DA's office contacted them over a year ago. We decided not to call them because we realized It doesn't matter if Regina was dealing drugs. What matters is that the officer cannot kick in someone's door, cannot violate their constitutional rights, cannot bring other officers in with him and get into a shootout and be justified. It's impossible. Now, Mr. Forst. While Mr. Forst is setting this up for us, I want to talk to you about Patricia Garcia. I told you that she's the author of this story and that Gerald Goines becomes her editor-in-chief. And the truth of the matter is that Patricia Garcia pled federally
Objection
to
to facts
life.
and evidence.
Sustained.
Ask that the jury be instructed to disregard.
Disregard that last statement.
Move for a mistrial.
All right, please continue.
Patricia Garcia took responsibility for her lies that started this.
Objection, same objection.
Sustained.
And ask that the jury be instructed to disregard
Please disregard that last statement.
and move for mistrial.
All right, please continue.
The person who started this isn't here to testify before you today. And remember in jury selection when we said,
Objection, Your Honor, that is burden shifting. It is their responsibility to prove their case.
Overruled, please continue.
remember we said in jury selection that the defense has the exact same subpoena power as the state if they choose to put on a
Objection,
case.
that is improper argument and burden shifting.
Sustained.
And ask that the jury be instructed to disregard,
Please disregard that last statement.
request a mistrial.
All right, please continue.
If the defense chooses to put on a case, they can call whoever they want.
Objection to the burden shifting, Your Honor. Improper argument. We do need to approach it this time.
Gentlemen, further instructions, as you can see in the jury charge as well, state, as you probably heard many times by now, the state has a burden of gentlemen, further instructions, as you can see in the jury charge as well. The state, as you've probably heard many times by now, the state has a burden of proof in all criminal cases. That burden never shifts to the defense. It stays with the state throughout the entirety of the trial. Okay? Please continue.
Thank you, Judge. They chose to call 3 witnesses, and none of those witnesses could tell you anything about Gerald Goines falsifying this search warrant. They want you to forget to remember that there is no confidential informant. Forget to remember that he stood in front of Judge Markham, raised his hand, swore an oath that everything in that affidavit to the search warrant was true. Forget to remember that that happened on the exact same day that they went to execute the warrant. Now, isn't that strange to you? If you did any sort of investigation, why would you enter an offense report that's 1 sentence long on the same day that you swear before the judge, on the same day that you go execute the search warrant? Now, you may not be narcotics officers, you may not be police officers, but you have to admit to yourself that that's highly irregular. But they want you to forget to remember. They want to make you think about Dennis Tuttle's medical records, about Regina Nicholas and her text messages. But I want you to remember why we're here. I want you to remember that Gerald Goines, in the aftermath, I want you to remember that he was still lying when Lieutenant Todd came and tried to ask him, what's going on? Who is the CI? They want you to forget to remember that when he talked to Sergeant Bass, that he continued those same lies with Sergeant Bass. See, this is why we're here. All of this stuff about text messages and mental health records have nothing to do with why we are actually here. The baggies of heroin, I believe I tag it, the baggies of heroin that he had been riding around in his vehicle for an entire week that should have been tagged into narcotics. You have to ask yourself, what is the purpose of a narcotics officer who's riding around with with 2 baggies of heroin in his vehicle where he knew that he had already lied in a search warrant? What is the purpose of that? You sit and you think about that for a moment. A 30-year narcotics officer who doesn't go tag dope after he gets it from someone else's house, just happens to be the dope that he says is going to be at 7815 Harding Street in that search warrant. And lo and behold, when things hit the fan, he sends his friend to his vehicle to get the heroin from a whole other operation. And you ask yourself why we're here. They don't want to talk about that. Now, so when our indictment says that it is a search warrant would you pull it up here? Mm-hmm. When our indictment says that he did then and there unlawfully commit and attempt to commit the felony offense of tampering with a governmental record by making, presenting, and using that governmental record with knowledge of its falsity, well, we know that he had knowledge that it was false. As Mr. Forrest told you, check it off. And while in the course of and the furtherance of the commission, the attempted commission, and the immediate flight from the commission and attempted commission of said felony, he did commit and attempt to commit an act clearly dangerous to human life, to wit, causing armed peace officers to make forcible entry into a residence through the use of a no-knock search warrant based on false information.
Objection, Your Honor, that's not an act, misstatement of the law.
Causing armed peace officers to make forcible entries into a residence through the use of a no-knock search warrant based on false information. Now you ask yourself, did he cause armed peace officers to make forcible entry into that residence at 7815 Harding Street through the use of a no-knock search warrant that was based on false information? Where's the false information? In the affidavit. So when you get the instruction in the jury charge, to wit, an affidavit in support of application for a search warrant, that is what we're talking about. And it's no question that this caused the death of Regina Nicholas and that this caused the death of Dennis Tuttle. In talking about the justification defense, the defense attorney told you, we want to run from that. No, we want to embrace that, and here's why. What the instruction will tell you for justification on page 14 of your jury charge, the actor at the very top, very first paragraph, the actor reasonably believes the arrest or search is lawful, or if the arrest or search is made under a warrant, he reasonably believes the warrant is valid. That does not apply, can never apply to Gerald Goines, because Gerald Goines knows that this is not valid. So that the warrant is not valid. So this whole justification.
Your Honor, this is not what the justification instruction is about, misstatement of law. It applies to Gallegos, which is what the jurors have to consider.
Again, ladies and gentlemen, the law is in here. The attorney's interpretation of the law is what they're doing in your closing arguments. Please continue.
Applies to Gallegos, but it doesn't apply to Gerald Goines, which is what my point is.
Objection, Your Honor, that's a misstatement of law.
Could never apply to Gerald Goines because Gerald Goines knows that this search warrant is invalid. So we embrace this language, this justification language. We're not running from it because we know that it could never apply to the person who falsified the search warrant in the first place. The defense attorney talked about justice. Let me tell you what that word justice is. It's the word just. It has the word ice on the end of it. And so what they want you to do is they want you to think of this in a vacuum, no feelings whatsoever. They want you to take the evidence back, look at the evidence, and somehow not think about what happened to Dennis Tuttle and Regina Nicholas. And what we want you to do, we want you to decide this case based upon the facts and the evidence. But we also know that you are human. Because if you take ice, just that last part of the word justice, ice, then you would be doing nothing better than what Gerald Goines did. Went in coldly to that house, brought police officers into that house, and massacred those individuals. And we don't want that. We've had enough death in this case. So you don't have to put your feelings aside when you are deciding this case. The other thing, I told you I came in with prepared argument, and I did. But everything that the defense attorney says, I feel like I need to respond to because there was a lot of spin that was put on it.
Objection, striking at the defendant over the shoulders of counsel.
You're here to answer one question. Is the Constitution worth fighting for? Is the Constitution worth fighting for? Does a person's Fourth Amendment rights mean anything? We know that it didn't mean anything to this defendant. But he doesn't get to write the final chapter. The final chapter gets to be written by you. And you can tell the Nicholas family and the Tuttle family that this was unjustified, that their deaths are going to be, someone is going to be held accountable for their deaths. Or you can do the exact same thing that Gerald Goines did. Mr. Forsch talked to you about why you're here, because we spoke with each of you individually. And the reason that you're here is because you each said that you could follow the law. You each assured us that you would listen to the evidence, listen to the witnesses, that you would not decide this case based upon emotion, but you would also be stewards of the law. And that's what we have to have. Because the person on trial was not a steward of the law. And we're going to ask that you go back, you sign this verdict form. We, the jury, find the defendant, Gerald Goines, guilty of felony murder, because that's what he deserves. And when you sign this verdict form, please make it nice and legible. Make it very clear. Sign it with an exclamation point. Gerald Goines is the cause of those officers who got shot. He's responsible for every officer who went into that house. And just because Dennis Tuttle has military training, just because Dennis Tuttle is coming from the back room and he's taking shots, does not exonerate Gerald Goines. You have to remember, but for, Mr. Forsch started out talking about but for causation. But for Gerald Goines, would any of this have happened? And the answer is no.
Objection, Your Honor, that's not the legal standard. They have the instructions. Again, ladies and gentlemen, you do have the instructions on this case and the charge. Again, whatever the attorneys are saying is their summation of what they believe the law to be.
When a person shows you who they are, you have to believe them. And what have you seen about Gerald Goines in this case? Other than he's willing to lie repeatedly. He's willing to frame live individuals and dead individuals. He's responsible for causing those peace officers to make forcible entry into that residence at 7815 Harding Street and causing the death of Dennis and Regina Tuttle. Folks, this case is simple. We just ask for your signature on that final chapter.
All right, ladies and gentlemen, you've heard all the evidence, you've heard all the summations from both sides. At this point, my instructions before that you cannot talk to each other. You can definitely talk to each other now. We'll wait for your deliberation. Yes?
All rise for the jury. Good night.
All right, please have a seat. Court will be in recess till we hear back from the jury.
Oh, yeah.